Virginia prosecutors are revolting against their governor's most recent gun control legislation.
Abigail, you have nothing to say? Abigail.
Her approval rating, she is the lowest rated governor in modern Virginia history for a reason.
Have you nothing to say about that? Are you not going to address it?
This is the absurdity. This is the perfect example of the absurdity in Richmond and the attack on our Second Amendment rights.
Lawsuits are in the works, and even some prosecutors around the Commonwealth say they won't enforce it.
Tell you that I'm going to dog-ear this floor speech and put it in the category of I told you so that we can get back to this.
All right, we have major breaking news out of Virginia, and this one is genuinely insane. The Virginia State Police just announced they are enforcing universal background checks on private gun sales again, despite the fact that a permanent court injunction, a binding court order from the 24th Judicial Circuit Court of Virginia, explicitly says they cannot do that. Gun Owners of America and the Virginia Citizens Defense League are now filing a motion for contempt of court against the Virginia State Police. Let me say that again. Two of the largest gun rights organizations in the country are asking a court to hold the Virginia State Police in contempt for willfully violating a permanent injunction. If you live in Virginia and you own firearms, this affects you directly right now. Today, if you try to conduct a private firearms transaction, a sale between two private individuals that has been legal for the entire history of the Commonwealth, the Virginia State Police are running background checks on those transactions as if the court order does not exist. If you are between the ages of 18 and 20, this is even worse for you. The entire reason the court struck down this statute in the first place is that it made it functionally impossible for you to exercise your constitutional right to keep and bear arms. The court already ruled this was unconstitutional. It is not a suggestion. It is not an advisory opinion. It is a permanent injunction, and the state police are ignoring it because the Virginia legislature told them to. That should concern every single gun owner in this country, not just in Virginia. If a state legislature can simply pass a new law ordering law enforcement to ignore a court ruling, then court rulings protecting your rights mean absolutely nothing. So let me walk you through exactly how we got here, because this goes deeper than most people realize. The original statute at the center of this is Virginia Code Section 18.2-308.2:5. That is the universal background check law that requires background checks on private firearm sales. Gun Owners of America and the Virginia Citizens Defense League challenged this law in court, arguing that it was unconstitutional. The case went before the 24th Judicial Circuit Court of Virginia. Judge Eames, the presiding judge, issued a ruling that was about as clear as a court ruling can possibly be. The court wrote, quote, "The court finds itself left with one option at this time, and that is to strike the statute entirely. The court grants the plaintiff's request for permanent injunctive relief, enjoining the administration, enforcement, and imposition of Virginia Code Section 18.2-308.2:5, end quote. That is a permanent injunction. Permanent. Not temporary, not conditional, not subject to legislative override. The court said this law is unconstitutional and you cannot enforce it. Period. The core reasoning was straightforward and grounded in established Second Amendment jurisprudence. The universal background check requirement, as applied, effectively barred individuals between the ages of 18 and 20 from acquiring firearms through private sales. Because the federal background check system, NICS, that is the National Instant Criminal Background Check System, does not process checks for individuals under 21 purchasing handguns through licensed dealers. The practical effect of requiring background checks on all private sales was to create a complete barrier for 18 to 20-year-olds. The court found this was an unconstitutional infringement on their right to keep and bear arms under both the Second Amendment and the Virginia Constitution. This tracks directly with the analytical framework established in New York State Rifle and Pistol Association v. Bruin, the landmark 2022 Supreme Court decision. That decision requires any firearms regulation to be consistent with the historical tradition of firearms regulation at the time of the founding. The court looked at this law, applied the Bruin test, and said there is no historical analog for barring legal adults from acquiring firearms.
House Bill 1525, which is intended to disallow anybody under the age of 21 to purchase, transfer, or possess a firearm.
What this bill does is directs the Virginia State Police to enforce something that a court in the Commonwealth of Virginia has said very clearly they cannot enforce. We can look back to the age of the young men and women who fought to free America some 250 years ago. This is going to come forward. It is going to be challenged. It is going to fail. I am going to say I told you so.
Now here is where it gets truly outrageous. Earlier this year, the Virginia legislature, with Democrats in control, passed what can only be described as a legislative override of a court order. They passed a new bill that essentially directed the Virginia State Police to enforce the universal background check requirement on private sales regardless of the existing permanent injunction. This was not some accident. This was not a case of legislators being unaware of the court ruling. Members of the Virginia House GOP stood on the floor and explicitly warned their colleagues that this bill, which has been referenced in connection with HB 5P 1525, directly contradicts both the 24th Circuit Court's permanent injunction and the Bruin decision from the United States Supreme Court. One delegate laid it out in terms that could not have been more clear. What this bill does is direct the Virginia State Police to enforce something that a court in the Commonwealth of Virginia has said very clearly they cannot enforce. He went further. He pointed out that the Fifth Circuit Court of Appeals has already ruled on the underlying age-related issue in a case involving the same legal principles, coming down on the side of Second Amendment rights. He noted that the United States Supreme Court has been considering related petitions on this exact question, and then he made a prediction. He said this law is going to be challenged, it is going to fail. And he would say, "I told you so," not with glee, but with regret. The Commonwealth will have wasted millions of taxpayer dollars defending what is, in his words, clearly indefensible. He was right. And now we are watching his prediction come true in real time. Let me put this in the broader context, because this is not happening in a vacuum. Across the country right now, we are seeing a pattern where state governments, particularly those with anti-Second Amendment majorities, are openly defying court rulings that protect your rights. We saw it in California with magazine bans after Duncan v. Bonta. We saw it in Illinois with challenges to the assault weapons ban. We are seeing it in New York, where the state legislature passed new carry restrictions almost immediately after the Supreme Court struck down their old permitting regime in the Bruin decision. Virginia is now following the same playbook. The strategy is simple, and it is cynical. Lose in court, then pass a new law that does the same thing. Force gun owners to spend more money and more time challenging the new law, and keep your unconstitutional policy in effect for as long as possible. While the legal process plays out, it is government by attrition, and now they have added a new chapter to the playbook, which is to pass a law that explicitly orders law enforcement to ignore the court ruling entirely. That is what is happening in Virginia right now, and it is a direct challenge to the rule of law itself. The contempt motion filed by Gun Owners of America and the Virginia Citizens Defense League is the right move, and it is the only move available right now. They are going back to the court that issued the permanent injunction and saying, "Your order is being violated. Hold the Virginia State Police in contempt." Is this going to result in anyone going to jail? Probably not. I will be honest with you. Is Governor Spanberger going to face personal legal consequences? Almost certainly not, at least not in the short term. What will most likely happen is the court will reaffirm its injunction, potentially with stronger enforcement language, and order the state police to stop. The state police will comply with the court order because they will have no choice at that point. But here's the thing. The damage is being done right now today while the enforcement is happening. Every private sale that is being subjected to an unconstitutional background check right now is a violation of someone's rights. Every 18 to 20-year-old who is being denied the ability to purchase a firearm through a private sale right now is having their constitutional rights infringed under a law that a court has already struck down. That is not theoretical harm. That is real. Looking ahead, I think the Supreme Court is going to start cleaning this up. We have multiple cases in the pipeline that touch on these exact issues. Age-based restrictions, the scope of Bruin's historical test, and the limits of state power to regulate private firearms transactions. But that is a process that takes years. And in the meantime, states like Virginia are exploiting the gap. So here's where things stand right now. If you're in Virginia, the state police are currently enforcing universal background checks on private sales despite the permanent injunction from the 24th Circuit Court. Gun Owners of America and the Virginia Citizens Defense League have filed a motion for contempt. That motion will be heard by the court, and I expect a ruling relatively quickly given the urgency. Your rights under the court's original ruling have not changed. The injunction is still legally binding. The state police are simply choosing to ignore it on the orders of the legislature. Watch this space closely. I will have an update the moment the court rules on the contempt motion. That is it for today, folks. See you in the next video.